You may have questions about the trademark process, right? Trademark registration. You probably hear all the time, register your trademark, get a trademark. And you might be wondering, do I even need a trademark? But when you decide to embark on the journey, you may have questions about the process that your application is going to go through so that you understand and have some kind of understanding of where you're going to be in the process, but also what the journey to trademark registration is going to be when you get on the road to R. And so I want to share with you one of the graphics that I have created together because some of us are visual learners, some of us are kinesthetic learners, but this can help you put together the pieces to understand the journey of getting to R, which is trademark registration, a registered federal trademark. So before I show that, let me just briefly introduce myself so you know who's talking to you. I am Shayla Jackson. I'm a trademark and business attorney, and I'm also the CEO and founder of my law firm, Legacy Legal and Consulting Firm. What we do is we help purpose-driven CEOs who are on the go get access to trusted legal counsel no matter where they are. We are a virtual law firm and we help our clients protect their brand, build a legacy, and secure their wealth. And one of the ways that we do that is by helping them protect their brand with trademarks. And that is through trademark registration. So no matter what state you're in the United States, or even if you're outside of the United States, but you want trademark protection rights for your brand in the US, we can help you at Legacy Legal do that if you want to protect your brand with trademarks. But first, one of the things that comes up oftentimes is that there is so much confusion about the trademark process or what happens at what stage. So hopefully this video will clear up the confusion and provide you the clarity you need to understand what the process and the journey is going to look like as you journey on the road to R. Now, let me just share with you that, guys, I have a teaching background. So the way I teach is so that you understand because you did not go to law school, okay? So let's make sure that you understand what I'm talking about. So when we talk about the road to R, I want you to think about driving. When you are driving, you're trying to get to your destination. And so with your trademark application, your goal is to get to the destination of what? Being able to use that R symbol, being able to say, I have a federally registered trademark, my brand is protected. Okay, so to understand this journey, I want you to think about a road trip that you're about to go on. Now, when you are about to get on the road, what do they recommend you do? They recommend you do a safety inspection check, right? You go get your oil change, you check the oil. You might want to make sure that the engine is good, that there will be the tires are good, rotated, filled with the proper amount of air. Why? Because you don't want to get on the road to your destination and then be stuck and stranded somewhere. Why? Because you did not check to see if there was anything wrong before you got on this journey. And so, in the trademark world, before you ever file a trademark application with the USPTO, which stands for the United States Patent and Trademark Office, which is the federal agency in which you would file your trademark application for trademark registration at the federal level, you would conduct a safety inspection check, which is called a trademark legal clearance search. This is where, if there are any issues in terms of an existing trademark or something that is likely to be confused and show up as a block, as a emergency stop, as a red flag to your application, this is where it would be possibly identified, but most likely it would be flagged when you properly conduct this search. Now, for many DIY filers, one of the mistakes they make is they only search the USPTO database, but that can come back to bite you in the butt and be a bad idea. And I'll tell you why when we get to that part of the process and journey. So the first thing is to conduct the search. If the search says It's good to go. There's no engine failure. There's no red flags. There's no reason why you can't go forward. Then we proceed with our first stop in the journey. We have to prepare and we have to file the trademark application. Until you file the trademark application, you're not in the USPTO database yet. Okay. So you got to file your trademark application. There are two options for this journey. I want you to think about when you're on the highway, how you have the express route and the scenic route. There are two journeys. There are two highways for this process, and you don't have to choose it. It's already chosen for you. So option number one is called a 1A application. This is the application you would file if you are already using your mark in business. That means you're already using it. The choice has already been made. It's a 1A application. But let's say that you haven't started using your mark yet, but you want to protect it before you start. Well, now you're in 1B. It's an intent to use. That means that you haven't started using it in business yet, but you have a bona fide intent. That means you are legit. You know for a fact, or you have a good firm belief and faith in that you will use this mark in the near future in business. And so those are your choices. It's chosen for you. If you're using the mark, it's a 1A application. If you are not, and you want to file preemptively, it's a 1B application. So that's the first stop. And then you get on the road. So now your road has been selected. Now, once you get on that road, now is when we are in the waiting game. Why? Because the next stop is that your application is going to be assigned to a examining attorney for review. And so the examining attorney is going to be assigned your application. Now, the examining attorney is the attorney at the USPTO office that's going to review your application for any issues, and they're going to tell you what issues are, or they're going to green light it and say you can go ahead. I want you to think about border control. I don't know if you've ever gone across the border. There was a time where I drove across the border from Michigan to Canada, and you get to the gate for border control, and what do? They start doing an inspection. They start looking and evaluating whether there are any risk before they either ask you for additional information to verify whether you're good or go, or tell you, you know what, there are some issues here that need to be corrected. We need to do additional investigation. Or they say you're good to go and wave you through. This is what's going to happen with your application. The trademark examining attorney is like a border control agent. They're reviewing it for risk. They may have questions or they may wave you through. And so the timeline for this process for your application, once it's submitted, for it to be assigned to an examining attorney, can be anywhere from 6 months to 12 months. We don't really know. It just depends on the USPTO. But once it's assigned, if there are any issues that they find with your application, now our next stop is going to be office actions. Office actions is an official response or an official letter noticing you from the examining attorney. What red flags did they see? What information do they need? What needs to be changed? What red flags are blocking your application that until this is fixed, you cannot make it to your destination of a trademark registration. Now, the other thing that it may do is say, guess what? You cannot move forward. And so at this stage of the process, it is possible that you may have your application kicked out of the process altogether. Now, once they submit an office action, what's required is a response. And so you'll have 3 months from the date of the office action to respond. Now, your response is saying, hey, here's why it's not an issue. Here's why we can actually overcome this issue. But it's a response to what the examining attorney has mentioned in the office action. And so you have 3 months to respond unless you file an extension. Now, here is where I've seen DIY filers make a mistake. And this is where they fail to respond within the time period. If you don't respond, guess what? your application is abandoned. And if you don't revive within the 2-month grace period, then what happens is you have to start the journey all over. It's kind of like a go home, Roger. I don't know if you've ever seen Sister Sister, but go home, Roger. You got to go home. And if you had a legitimate trademark, meaning that it was eligible for trademark protection and registration, then you have to pay the filing fee all over again, which as of date in 2025 is $350 per class, per mark. But your application is out of the process. The journey has ended. Go home, Roger. So you want to make sure that you're responding within that 3-month grace period. Now, if you successfully respond to the office action, or there were no issues with your application and the trademark examining attorney said you're good to go, then you move on to stop number 4. Stop number 4 is the publication in the Gazette. This essentially says, look, we have already cleared this application for registration, but now we want to give notice to the public and other businesses if they have any rights they want to assert. So one of my favorite shows is A Different World. Oh, I love me some Dwayne and Whitley. And so one of my favorite episodes is where Dwayne showed up at the wedding of Whitley to object. He objected to her marriage. And so this stop is where people who have a claim or want to claim can object to your trademark application from being registered, your trademark from being registered. And so when they object, they file what's called a notice of opposition. And if they file that notice within the time frame, now instead of you moving forward on the journey to registration and getting to your destination, now we got a pit stop. I don't know how many of you ever made a pit stop on a road trip, but now we got a pit stop. Now, here is what happens in the pit stop. When someone issues a notice of opposition, they're essentially saying, I object to this registration. I object to this trademark. And so now you are kicked out of the traditional traditional process of the USPTO trademark application. And you are now at a pit stop where you are before the TTAB board, which is where now you got to fight. Now there's a litigation. You got to fight this battle. And so in this battle, now you got to respond to the opposition. Now you got to overcome. If you lose here, you are now at the same position as before. Go home, Roger. You lost. And now that means because you lost, you cannot use that trademark because of the opposition. You don't have trademark protection or rights. Okay. So you have to win at this stage or your journey, the road to R is over for this mark. Now, if you win, then you get back on the road to your destination. But if you lose, it's go home, Roger. That's it. So once you overcome the opposition, you win, then you get back on the road. Now, if your application was filed as a 1B, meaning you're not using the mark, but you intended to use the mark when you filed the application, then the next stop is only for you. That means that at this stop, what happens is that the examining attorney has already said your application is green lit. However, you have to provide additional information. Why? Because trademark rights are not for ideas, they're for marks, trademarks that are actually already in use. You got to be using it. If you're not using it, there's no trademark rights. So because you weren't using it when you filed your application, stop number 5 is only for those applicants who were 1B applicants, because now they're saying you have to provide us with proof you're using it before we allow you to get to your destination. And so this is what's called a notice of allowance. It's saying, look, now give us your proof of how you're using it. And so you have to submit a response. You have to submit your statement of use. You have to submit proof, your evidence. This is how I'm using the mark in real business. And so you typically have 6 months to respond to a notice of allowance. Now you can extend it if you need more time, you're not using the mark yet, you can extend it, but you have 6 months. If you don't respond within the 6 months, guess what? Go home, Roger. Your application will be abandoned. You have to respond to official letters from the USPTO. But if you respond, you submit your evidence, everything is good, then guess what? Just like the 1A application, now everything is good. You successfully passed every stop, every turn off. You're cleared. Now you have reached your destination of R. Your trademark application has been approved and your trademark has been registered. Congratulations. And so this is an amazing process. You can officially use the R symbol. But here is the thing. Just because you have a registration, a registered trademark, that's not the end of the journey. So in order to stay at your destination of a registered trademark, you have to maintain and renew it. Maintain and renew it. And so within the first 10 years after your registration has been approved, between year 5 and 6, you have to file for your maintenance documents saying, look, I have maintained my trademark. This is how I'm still using it. Now, within year 9 and 10, you also have to file your maintenance doc saying, I'm still using it. So this is the proof. They want to know, are you still using it in business? Because trademark rights are based on use. If you stop using it, your rights are no more. After those two filings in the first 10 years, now you only have to file your documents for maintenance and renewal every 10-year period after that. So your total trip time from the stop 1 to the final destination of your trademark application being approved and you have a federal registered trademark can be anywhere between 12 to 18 plus months. It really just depends, because again, if your application has any issues and there's an office action, then guess what? The time period gets extended. If you file an extension, the time period gets extended. If you have a pit stop and you have to fight a opposition, the time period of your journey gets extended. And this is why it's hard to say how long one trademark application's journey is going to be versus another. And so one mistake that DIY filers make that ruins their success and opportunity to reach their destination is that sometimes they get shocked, fear when they get an office action and they fail to respond and they fail to meet the deadlines. This is very heavy on deadlines. You have to meet the deadline or your application will be suspended. Excuse me, correction, abandoned, not suspended, abandoned. And so that's a go home, Roger. And so that is the road to R. And so I hope this gave you some clarity on the trademark registration process. How do you go from the beginning to the end of the process, but also gave you some insight that just because you got to use the R and your trademark is registered, that's not the end. So if you are looking to trademark, consider trademarking with legacy. And so trademark with legacy, you can go to trademarkwithlegacy.com and schedule a free discovery call so we can learn a little bit more about you, your trademark, and then sit you scheduled for a trademark consultation so we can do the safety inspection check to start the process before you start your journey on the road to R.